All right, video 3, let's move into law. Okay, what do I got written here? Law. Everyone chooses for themselves, right? You have to, that has to be right in order for dominion before it to be right. Okay? Let's say we're going to follow syllogism here to say that everything's in perfect order. It's our misinterpretation or ignorance of what that order is that gets us into trouble and into confusion, and thereby we're now relegated to the belief, and that belief is the impurity that then distorts our reality and commingles our reality, then get us lost in within different elements of the law, and thereby creates an obligation we don't even know that we're obligated to by our own misinterpretation of what law is. I don't know if I that sounded a bit of convoluted there, but let's see if we can develop what I was trying to say there through what I've written here. One cannot grant, convey, alienate, gift, will, dispose of, or otherwise without first having the legal right to the very thing being transferred over to another. You cannot pass over to someone that you don't first possess. Makes common sense. Okay. In common law, an estate in land was transferred via livery-accession and was the only way in which the land could be conveyed. Now I think it's best that I can, before we get into that, when I jumped into this, is to come to the understanding what is law, what is English law. Well, English law is a hierarchical system of land, of holding an interest in land. It doesn't govern people because people are with dominion. It governs over agreements, and agreements are to those interested in land. So it governs land based on a hierarchical system where everything from top down follows, just like top down it follows that you have dominion over the earth. The next thing is that we got to create agreements in order to make sure that dominion is never interfered with. So we create law, which is God in this realm. And everyone chooses for themselves what law they want to use in order to affect their will and their free will to interact with society. You have always had that. You've never not had it. You are making those agreements right now voluntarily, but you may not, in most cases, understand what agreements you're making to find yourself that, why am I obligated to something, and why am I getting penalized? Why am I getting thrown into jail? Why am I getting fines? Why do I have to pay taxes? Why are those things happening? Well, because you're in agreement somewhere along the line. It's assumed that you've made the agreement by your own actions to possess those things within the agreement itself. Okay, so the very first foundation of law to land was a hierarchical system, which began before 1086. But for this term, we're going to start from AD 1066, when William the Conqueror, William the Purchaser, usurped the throne and created a militant style form of land holdings, whereby he gave certain knights power to hold over a tenure of land based on their personal agreement to be in allegiance with the king, to fulfill the obligations of holding this new rights to land, whereby each one supports each other, and by doing so, the whole collective, the whole entirety agreement, the whole God is held together. And that was based on each individual's agreement to one core cause, which held in the monarchy or the king of that time. And the king was to be the absolute end of where the land is held. So everything is cheated back to the king. Everything was held in the king in one central core. We can just call it a trust. The fideicommissium is that everyone's agreed that land is going to be held in one central area, to each person in that centralization will make an agreement too, and for that they'll do a service to protect that interest by forming by being a knight, which we call barons, or a tenant-in-chief, and that knight will then command an army of subsequent knights, which they became lords, so division down like the pyramid, and they hold a certain area, unless for lack of a better word, an acreage, that they'll hold, and back in that time it would be metes and bounds, and then they are the management or the administrators over those who want to be protected under that manner, who they prayed to the Lord and gave them their full allegiance to the Lord. To the Lord then gave allegiance to the king, and each one was protected within itself for the rights that they were given to hold that peace, which again is subdivided. So villanelles will have a certain right, but serfs and peasants will have a less right, and women and children even a lesser right. Everybody just upheld the land tenure system, or the feudal land tenure system, by giving a subsequent allegiance to each other higher title before it, to which then became lords, and then that lord answered to a baron, and that baron had a personal agreement to the king, which that was the common law, and you had to have a legal title in common law to hold an interest. There was no equitable title at that time. It was, you're still a tenant as a baron, but you only had a legal title. There was nothing else, and that's all the common law established. And I might have developed it a little bit more, but I think that needed to, because I went into Liber Incision, and Liber Incision meant that it was a system what had to be witnessed physically, whereby you had a staff or a twig or a rock, whatever it is, that came from the land that you held, and through a complement of other witnesses, and in most cases a fioffer, which we call in layman terms today as a trustee, that you gave to the fioffer to hold for that moment, to show that they witnessed and held your land interest, and now you're going to pass it on to a new party. Okay. To further speak a little bit more about law, but so that's Liber Incision, and it was only common law, and it had to be, there was no paper per se that transferred a title. It was done by a physical act of something that was tangible, like a rock or a piece of wood or whatever. That's how you transfer land. And also in that time, land was through a patriarchal system of a bloodline, that your firstborn were given all the rights to give allegiance in the common law as it was given, that you were given as the baron. And that was how the system transferred and noticed property rights. But if you died as a knight, you didn't have a firstborn, it went back to the king. If you did not do something that was unsavory or was unpopular to the king, you were showing some means in which you were trying to control an interest that wasn't for the benefit of the whole. You could be usurped. The land could be usurped. There was a lot of different things that could remove you from that right of having that land. But if you were the firstborn, you had the first right to then, when your father died, you were then given the first right to now pay allegiance to the king, and given the sacrosanct fee, or the service. That's what it was. It's called a fee. It was a service to the king in order to offer that knight service, to which then commanded an army, to which that knights, lords, commanded villaines, and they commanded serfs and peasants and so forth. Okay. So maybe we'll stop there, and we'll go on to, I think we're going to video 4.